Ever wondered what happens to your property when you die? Well, I know you have heard about wills, but do you have one? Do you know what a will is? Maybe why you should have one? What should be in there? What does it cost? Well, we'll be exploring answers to these questions in today's edition of Carib Nation.
This is Carib Nation Television, the source for news and information about the Caribbean and the diaspora. Seen locally in the Washington, D.C. area on MHZ Network, Saturdays at 1:30 p.m. and Wednesdays at 11:30 a.m. and on the World Wide Web at CaribNationTV.com. Carib Nation, the television for one people, one culture, one Caribbean, one nation.
Welcome to this edition of Carib Nation. I'm your host, John Blake, and on today's program, we're going to talk about a topic that a lot of people try to avoid because it has to do with dying, just like life insurance. Few people want to talk about life insurance. I think uppermost to life insurance is preparation of a will. We have with us two attorneys who are going to help us on today's program to understand what a will is, why have it, what you want to put in it, and how much does it cost. We'll talk about that as well with our special guest. To my right is attorney Franklin N. Burke, and his practice is in Washington, D.C. We'll tell you about that in a little while. And also with us is attorney Dennis Beard, who's also in the Washington metro area in Silver Spring. Welcome, gentlemen. It's good to have you here, and I'm sure we're going to learn a lot in today's program about wills and probate.
Glad to be here, John.
It's a pleasure being here, John.
Well, let's start off with the basics, okay? What is a will?
A will is a statement, a written statement by a person disposing of their property to others in anticipation of death. The will becomes effective after the person's died. So that's basically what a will is.
Mm-hmm. Dennis, anything you want to add to that?
Yes, I'm in agreement with Franklin. It's a legal document that distributes a person's property in accordance with his intentions or his wishes.
Mm-hmm. Now, statistics have shown that a lot of people die without having this document. Excuse me. Do you think it's because people are really avoiding this whole thing of who gets what when I die, particularly if it has to do with death? Do you think that's why people avoid it?
Well, people tend to believe that to procrastinate the making of a will. They tend to believe that I'm not ready to die right now.
If you put it off, you put off death.
That's correct. And basically, death, of course, is not inevitable. You will die sometime. So people ought to confront themselves with the idea that they will die, and also they should actually make a will. Mm-hmm. Now, if a person dies without making a will, then that person is said to die intestate.
Right.
As a result of that, the controlling the distribution of your property will be dictated by the state or by the court.
And you don't want to have that happen to you, because that sounds like a whole heap of problems can happen. People can end up with your property that you don't want to have your property.
That's correct. That's
okay.
correct.
Just define this intestate process and how that takes place.
Okay. Basically, you die intestate, it means simply you did not make a will. Okay? And as a result of that, you do not get a chance or the opportunity to designate a personal representative. The court will designate a personal representative for your estate, which means that a person whom you may decide to distribute your estate would not be present to do that. Mm-hmm. That person is not there to distribute your estate in accordance with your wishes. Mm-hmm. In addition to that, the fact that you die intestate means that the court will distribute your property pursuant to a formula. And that formula is going to vary from state to state. For instance, the court might say, you know, you get your wife, if you have a spouse, you'll get 50% of the property. Your children might get, you know, 25%. If you have 2 children, 25% each. Now, what happens if you have another child that basically is not around, but suddenly this child hears that you have died? That child now can come in and participate in whatever property.
This is in the instance of it being interstate.
That's correct.
Without the will.
Without the will. So that child can, or any children unknown to you, basically can come in and lay claim to your estate. And basically, with a will, this prevents such an incident from occurring. You were in control of your property. You were in control of who you would like to have your assets distributed to upon your death.
This example you give us here seems to even extend beyond children. You may have some other folks who realize, well, this guy, he got a nice stash of money over there in the bank. We know that he's making good cash. Maybe I can get some of that. Doesn't it extend beyond children sometimes, Franklin?
Not really. If the person who is making the will, if they identify all the children.
This is without the will.
Without the will.
Yeah,
No, it does not. It does not. Outside of the members of the family, for instance, if a person who dies and owns property but didn't make a will, then, as Dennis said, that there's a scheme set up by the state to determine how your property is distributed. And most jurisdictions, most states will have a scheme whereby if the person is married, his spouse would get a certain portion. If he has children, they will get a portion of that. And if he has no wife and survived by no children, then perhaps his siblings could stand to benefit from his estate.
Of course, it doesn't prevent other people from laying claim.
Yeah, they could,
but it's going to be difficult, is what you're saying.
They could make a claim, but they would have to prove their lineage to the person who passes on.
Yeah.
So that's...
We've heard of cases where people exactly do that, try to prove their lineage.
Yes, that is true.
And I wondered about that. How does that
It's possible place? Because you have some claimants who might say, okay, I'm a son or I'm a daughter.
Right.
And they may have been born out of wedlock or something, and they're going to now assert a claim. Okay, in situations like that.
So we kind of touched on why have a will. It seems that it will simplify matters in the event of this person's passing much easier than not having a will. Is that correct to say it's a much easier way to make sure the distribution of property is properly taking place?
Yes, it is, John. In addition to the simplification process, you save when you have made a will. You save because there are substantial taxes associated with when you die intestate. In addition to that, there are also expenses that are incurred when you die intestate. For instance, in a will, if you have a will or you make a will, you can waive the requirement of bond on your personal representative. If you die intestate, the personal representative who would be designated by the court or appointed by the court would definitely have to pay a bond.
Okay, so it's going to save you money to do it that way. The proper way, of course, make sure you get the will ahead of time.
Right.
Now, a lot of times we hear people talk about, well, that, you know, you're talking about attorneys, they're going to cost a lot of money. How expensive is a will? And I have a follow-up to that, but let's talk about cost.
In most wills, if it's a situation what is regarded generally as a simple will, it's not an expensive proposition for most attorneys if they become involved. In certain instances, people with simple property possessions can even do their own wills.
So they can get a will kit from the drugstore, wherever, the stationery store, business store that sells these.
It's possible.
And at least have an attorney look it over is what you'd recommend before the final document is drawn?
I would recommend if someone passes on and has many forms of property, you might have different types that does not lend itself to a simple fit the package of a simple will form, then he should certainly get a professional to I'd help him formulate that will and have it properly done. You remember that in most states there is a way, a formal way of having the will written and having it, testified to by witnesses. And so that has to be followed. Otherwise, later on, after the person passes on, that will comes up for determination whether or not it's an authentic will or whether or not it's valid. That is the essence of the probate process, to determine, and if it didn't have the required witnesses, it might be ruled invalid. And in that situation, the person who were left property in the will, they would no longer take according to that scheme that was left in the will, but the property would go according to the dying without a will, under that scheme, you see.
So it depends on how complex
Yes.
the situation is. How much property this person has would be one indication.
Correct.
Would you say?
I think that in terms of answering your question directly, the cost of making a will is modest. Okay, you
Give
have
us a range. I know you can't put a particular
correct. Well,
number.
it's
What's the
basically
range for?
it all depends on the extent or the time
Right.
which the attorney spends on it. An attorney might spend 2 or 3 hours on a simple will, assuming that you have a property and you have 2 children as well as a spouse, and you have personal property. So basically, a simple will would probably be within the range of $300 to $500.
Okay.
Assuming you have real estate, and then you have to take into consideration the provisions, how many provisions of the will you're going to include.
And I guess attorneys differ in terms of the price per hour.
That's correct.
So we have to keep that in mind.
But a simple will should not cost you more than approximately $300 to
Gives
$400
us some indication. And depending on how complex it gets, the price can go up
Exactly.
from there.
because the attorney would be required to expend more time in terms of drawing that
Right.
document.
Now, you're going to obviously save on expenses if you are able to, if you have a simple will, that is, use a kit, as they call them, a will kit, and then have an attorney look it over. If you have the forms, the relevant forms, you can save that way if it's a simple will.
Yeah, that's
Keeping
correct.
in mind it's a simple will. So it's not a bad idea to do that if the situation is simple.
Well, especially in light of the fact not all of us are independently wealthy, and
Right.
not all of us have
Precisely.
homes and the like. Those individuals who might have bank accounts, CDs and the like, personal property, fur, jewelry, and other aspects of personal property, they might want to go with a simple will. But if you're thinking in terms of once you hold real estate, for instance, and if you're looking, and if you have children who are potential heirs, you might want to definitely have a more professional will drawn up than a simple will, for the simple reason that you've actually had in the past several will contests, throughout America, throughout the Caribbean, and the like. And if you can avoid a will contest, it's appropriate. I'm in the process right now of probating a will. I'm not going to name names, of course, but it involves 9 sisters from part of the Caribbean. And basically the will was drawn up, and basically the mother left one house, real estate, for approximately 3 sisters or 3 daughters. The other 6, she gave individual bequests monetary contributions. But it's turning out that the actual house, of course, is more valued or valuable than the actual bequest, the monetary contributions that she left for the other sisters. So a situation like that presents a potential for will contest. And the other sisters, of course, can intercede and come in and contest that will and question whether or not the will was a valid will.
Which we got to keep in mind, your situation might be a little different, maybe a little more complex than what we regard as simple wills.
Correct.
So you may want to see either one of these attorneys or your attorney to get more information. At this end of the program, we will have the phone numbers up for you of these gentlemen. Now, we heard about life insurance being a substitute, and joint property, joint ownership of property being a substitute for a will. Is it really?
No, It's not a substitute. Joint ownership of property. Let's assume that you have a joint real estate, for instance. The survivor takes automatically. Similarly, in terms of insurance, for instance, you have a designated beneficiary who would take. But what happens to the other aspects of your property? That is left unattended. So for all intents and purposes, life insurance is not a substitute, nor is joint ownership of property a substitute. There have been situations whereby individuals have actually died later on in a car accident, for instance. Let's assume that one person dies today and the next day another person dies. That person does not have, the second person who dies doesn't have the time and the ability to actually go ahead and make a will. And hence, for all intents and purposes, you need, if it's a joint will, if it's a joint piece of property, then you need to have that person, the survivor, should not be available, is not available to make that will. So the point I'm trying to make is life insurance as well as joint property does not, or there's no substitute for making a will. A will is a document that you need for all intents and purposes. You should make that will as soon as possible. In the event of a catastrophe or some form of illness, the future is now as far as making wills are concerned.
Any further comments, Franklin?
Except that you remember now the formalities of making a will should be observed, and so there may be some laymen who do not observe the formalities in doing so, which can lead to serious consequences if that will is held to be invalid at the time when it's offered for probate. And what that means is that you offer the will to the regular authorities wherever they're placed to determine whether that will was proper. That's important because if you had a scheme under the will to distribute your property, and then there are people or relatives of yours who, if you did not have a will, or if the will is determined to be invalid, they would inherit your property. So it's of interest to you that you make sure that the formalities are observed. And in most of the states here in the U.S., and doing a will, you simply have to make sure that you have 2 witnesses to observe you signing the will. You don't have to let them see the provisions of the will, except that when you come to sign your will, you announce it to the witnesses that this is my will, and I'm going to sign it. And they in turn observe you do that, and they in turn now sign the will, indicated that they had watched you sign your will. And that observing the formalities of properly signing and making a will.
Which touches on the follow-up question that I have is, what are the requirements of a valid will?
Yes.
Which is something we need to address.
Right. The requirements of a valid will, you must be of an age 18 or older, and you must be of sound mind. In essence, an incompetent or a child cannot make a will. With respect to other formalities, you have the 2 signature requirement which Franklin referred to. But in addition to that, you should have that testator, as the person who is making the will is called, at least sign each and every page of that will to prevent or preclude substitutions of other pages. That's very important.
I'm sure.
And of course, a will has to be in writing. In the past, the olden days, a person might say orally, well, I leave this.
What about video? We heard about video, wills on video. Is that still legal in some states?
Well, it's still legal in some states, but basically the requirement is that the will be in writing. That's the requirement. That's the preferred way of disposing of your property in writing.
It's preferred, but it doesn't mean that video is
illegal. Not valid.
It's not valid.
It's still valid.
But it's not true for every state, is
That's
that
correct?
No.
So you need to check with your local attorneys to find out if that's something you can do.
Correct.
Now, talking about that, signature on each page brings up this question, can it be changed once you do the original will?
Can it be what?
Changed. Can
Well,
you change a will?
Certainly.
A will basically is not recorded while you're alive. It's not probated while you're alive. As a result of that, we call it this ambulatory. It means it can be changed at any time. The intent of the testator determines when the change will occur. If a will is changed, and that is called a codicil, right, or amendment to the will, it is executed with the same formalities of the original will.
Okay.
So if you have an existing will and you turn around and make a new will, you have to include in that provision that you're revoking all prior wills.
Okay.
Similarly, if you decide to go with a codicil, which is like an amendment to the will, it has to conform to the same testamentary requirements, and you still have to have the signature requirement, the actual signature, the two witnesses requirement, and the like.
So in other words, you have to redo the entire document. You don't just add a paragraph or insert or delete here. You must do over the entire document.
Correct.
Well,
If it's a codicil,
Right.
if a codicil is an amendment to a will,
Okay.
and the codicil, you can actually delete or amend certain provisions of that will. So with the codicil and the will, you're not executing a new document. You're not doing over the entire will. But what I'm saying, the codicil, if you make an amendment, which is called the codicil, right, you must execute it with the same formalities that you do for a will.
Okay.
Okay? Now, it depends on the nature and extent of your property. If you have had property, for instance, for the last 2 years, and there have been changes with respect to your beneficiaries, you may have married again, or you were subsequently divorced, you may want to actually execute a new will as opposed to a codicil. So it all depends on the nature and extent of your bounty, who your heirs are, basically whether or not certain properties have been acquired, additional properties rather, have been acquired in your life. That will determine whether or not you will execute a new will as opposed to a codicil.
Right. And don't forget, John, that in the will itself, when you make a new will, you can recite in that same will, the instant will, that you revoke all prior wills. So it doesn't create any confusion, because a later will in time revoking a prior will, it's a later will that's valid, and the previous will is no longer effective. So it's important, because if you have estate that there are changes over a period of time, multiple changes. Sometimes it might be a bit awkward if you're going, each time you anticipate a change, to create a codicil to amend the will. You might have several amendments. So it might be wise to, after some amendment, to make a new will if your circumstances
so
change.
Update as you go on in life.
2 to 3 years is recommended.
Every 2 or 3 years is recommended.
correct.
Just like you would any part of your financial planning or anything like that in your life. Life changes, and so you must change that document from time to time. So you say 2 to 3 years?
Yeah, well, 3 years basically, a minimum of 3 years, I would
3
say,
years.
not 2 years, minimum of 3 years.
Now, I'm thinking there are people out there viewing this program and say, well, I don't have much going on. Why would I need something like a will? Who is the question needs a will? Who needs to have a will?
I would say that everybody who have acquired property.
Okay, well, that's the question now. What would you consider as acquired property? Like,
Well,
I don't have a house. I do have a son. I have a job. I have some money in my bank, maybe about $10,000, $20,000 thereabouts. Should I really get a will?
My answer to that is yes.
Okay.
Because your bank accounts, your real estate, your personal property is all part of your property. And in case of death, you want to be sure that the people who would like to inherit that property is people who you have designated in your will, rather than a scheme set up by the state. So I would say in that circumstance, it's good and proper to have a will.
Agreed, Dennis, I'm sure?
Yes, I am in complete agreement with that, primarily because of the fact of what I alluded to earlier, the fact that without that will, that person is dying intestate. And once that person dies intestate, you no longer control who your
Gets your
heirs are.
property.
You no longer control whether or not the estate is going to be subject to substantial taxes or expenses. You no longer control who your personal representative is going to be. The personal representative is going to be someone trustworthy who will take care of your estate for you.
Right.
And of course, what's factored into the process is, what if you die, for instance, and you really and truly do not have someone, you have children, and you do not have someone who can really and truly take care of those children. Now, in a will, you can designate a guardian for the children, as well as a guardian for your property, to ensure that the children actually gets the property, i.e. if you want to designate and say a provision that this is for educational purposes and the like, which without the will, then the court has the ability now to appoint some stranger as guardian of the children or guardian of the property.
So it goes beyond the financial resources. It's also, as you say, who controls the raising of your children.
Exactly. You can put that, you're right. That's important because if you have children, most people might not know this, but like Dennis said, you can include provision in there that deal with the care of the children and set up even trusts. You can set up an arrangement in the will so that becomes effective upon death to take care of those children is important. So the will is a flexible instrument. You can include many different type of provisions in there regarding the disposition of your property. But the important thing I wanted to mention is a lot of people might not know. They say, well, I have a will. What do I do with it? How do I keep it safely? How do I ensure that it's handled properly upon my demise, upon my death? That's important, and I noticed that in some of these jurisdictions around here, different areas, they treat that differently. For instance, in the District of Columbia, they do not have a service where they could keep your will in safe keeping so that upon your death, someone with a death certificate will show up and be able to look at your will and to treat it accordingly. Whereas out in Prince George's County, the circuit court in the county, they're working through the orphans court, they call it. They have a provision out there where they can register your will and keep it for safekeeping. I think that's important.
Well, obviously, we need a lot more time that's available in this program to go through this whole question about having a will, having it properly written, overseen by an attorney. On behalf of the folks at Carib Nation, we thank you for viewing. Check us out on the internet at caribnationtv.com. I'm John Blake. Have a great week.